had a case a few years ago where the dad was working at a big company as a mechanic, making good money, almost $100,000 a year. Well, he did something wrong. He falsified records and he ends up getting fired. Well, there's a child support case pending at that time. And so when the case went to trial, we were able to show, and I was representing the mom at this time, but we were able to show that he was fired for misconduct and that when he was fired, he was making close to $100,000 a year. And we were able to argue that the court should use that amount as his income for child support purposes. The court agreed. Here's the situation. When you have lost your job because of some fault of your own, either misconduct or whatever the reason, the judge is still going to be able to use the amount of money that you were earning at the time of that misconduct, the time you were fired, as your income for child support purposes. Do you think that's fair? Mom was pregnant when she got married. Her husband knew it wasn't his biological child, but went ahead and accepted the child as his own anyway and signed the birth certificate, thinking, hey, we're going to live together from this point forward. We'll be one big happy family. He was wrong. They separated after a year. Problem is, nobody filed for divorce. They didn't have the money at the time. He went his way, she went hers. They each started dating different people as if they were never married. Well, she ended up having 4 more children over the next 10 years, none of whom were his biological children, and they were all by different guys. So now she's got 5 children by 5 different guys, none of whom are his biological children. The problem is the law presumes that they are his children. So now if he files for divorce, he's going to end up owing child support for 5 children, none of whom are his biological children. And he runs the risk of having to pay retroactive child support back to the date of separation. What he should have done is he should have filed for divorce when he separated. That would have been the easy solution. Now he's got a much more complicated problem. John was the father of 2 little girls, a 10-year-old and a 6-year-old, when he and his wife got divorced. He was ordered to pay child support of about $800 a month. This went on for about 8 years. 8 years into the divorce, the oldest child turned 18 and graduated from high school. John at that point felt like his child support should be cut in half and he should only be paying $400 because now he was only going to be supporting 1 child. What he didn't take into consideration was the fact that the guidelines, at least in Tennessee, as in most states, don't cut child support in half. For each child that you have in addition to the first child, you pay less and less of a percentage of your income for that additional child. Well, he didn't take that into account, nor did he take into account that his income had increased substantially over that 8-year period. John ended up paying $950 a month in child support for 1 child. In other words, his child support increased instead of decreasing. About a year ago, I had a case where a father of a child that had been born out of wedlock was ordered to pay child support, about $500 a month. And he had paid that child support for about 4 months until the parties got married. In other words, he married the mother of the child. And at that point, he stopped paying child support. Well, move forward 10 years and they're getting divorced. And guess what? The child support office now comes after him for all of those arrears, over $50,000 worth of back payments, even though he was married to the mother during all of that time. Well, that case went to court, and guess what? The judge ruled that he, in fact, owed that money. Well, move forward a year. I have another case, very similar to that case, where the father was ordered to pay child support, paid it for a little while, then the parties got married, then they got divorced, and the child support office came after him for that entire arrearage. But in this case, we had a different judge, and this judge decided the case on principles of equity and fairness instead of strictly on the law. Very interesting, because the cases were almost identical, but the outcomes were polar opposites. One judge followed the law, the other judge followed her feelings, her heart. She knew that it would be unfair to saddle that guy with that much child support when he had been living with that mother, married to her, and raising that child. It's a very interesting contrast, but it goes to show you that many times who you have as a judge makes all the difference in the world. Judges are human. Some judges will rule one way, other judges another. In these particular cases, the judges ruled completely opposite, but that happens. What is your remedy when that happens? Well, you can take it up on appeal, but I think in either one of those cases, the Court of Appeals would have probably affirmed the ruling of each of those judges because they were both right in their own respect. Bob and Julie got married in the state of Kentucky, where they continued to live together for about 10 years. Then Bob became disenchanted, left the marriage, left Kentucky, moved to Tennessee. When he was in Tennessee, he met a woman and he fell in love with her. Problem is, he didn't tell her about his marriage to Julie, and he knew that if he filed for divorce against Julie, that she was going to make it very difficult and drag it out. Bob wanted to marry his new girlfriend, though. So what he did is he went to court in Tennessee, filed an affidavit claiming he didn't know where Julie was, had looked for her but couldn't find her. So the court ordered publication of notice. After about 60 days, he went to court. He got a default judgment divorce against Julie. About 30 days later, he married his girlfriend. Well, somebody saw pictures on the internet of the two of them together, told Julie about it. Julie did a little investigation, came to Tennessee, hired a lawyer, got the divorce case set aside. That meant he was still married to Julie. That voided his marriage to his girlfriend.